In the previous lecture on contract law, we talked about offer, and in this lecture, we're going to be talking about acceptance. And the idea is that if you have these two concepts, then you have an agreement between the parties, and that helps to form the contract. As we talked about previously, there are other elements as well. So we're going to be looking at consideration and intention to create legal relations in further lectures. But the important part of any contract is the offer and acceptance creating that agreement. And so we do need to explore what it means to accept an offer, and that's what we're going to be doing in this lecture. So with that in mind, let's get started. We have previously talked about the different elements that make up a contract, and in this episode we're going to be focusing on acceptance. But really, offer and acceptance do sit quite closely together. When we're talking about acceptance, it's an offer that has to be accepted. But it's not always so obvious. So, for example, if you offered to buy something of mine and I accepted that, then that is a very clear example of offer and acceptance. But really, it's not always that straightforward, and so the courts tend to look for an agreement between the parties, a sort of meeting of minds, if you will. Now, the concept of acceptance itself can be split up into two key categories. Firstly, there's the fact of acceptance itself, as well as the communication of that acceptance, and that's how we're going to split this lecture up as well. So let's start off with the fact of acceptance, which is really just about asking the question about whether there has actually been an acceptance of the offer by the offeree. Now, in most circumstances, the offer will be accepted by either words, which can be written or spoken. So in a written contract, it could just be an "I accept your offer," or in spoken words, it's just the same thing, but spoken between the parties. However, it is also possible that the conduct of the parties themselves can actually constitute acceptance. So in Brogden and Metropolitan Rly Co, we had two companies that sort of had an unspoken agreement between them, and then there was the formalisation of that agreement into a contract, and it came up whether the contract had actually been accepted by one of the parties. And the evidence that was presented in court was that the two companies essentially carried on acting as if there had been an acceptance of the agreement. And so it was accepted that there could actually be an acceptance of an offer simply by the conduct of the parties, even if there hadn't been any spoken or written acceptance itself. This sort of view was confirmed in Hillas and Arcos, which is where the courts are likely to infer an intention that the parties do consider themselves to be bound by looking at the actions of those parties. However, it is important to note that the courts can't really just start going around inferring on contracts if it's not very clear that the parties have an intention to be bound to a particular contract. And one of the key things that the courts are looking for in that situation is how much certainty is there in the agreement between the parties. In other words, in the past lectures we talked about the idea that the parties might still be in negotiations. We talked about that in the offer lecture by describing as an invitation to treat. Now, if the parties are still in negotiations, then that's not clearly a completed agreement, and so the courts are not going to infer a contract in that situation. And that's what happened in Scammell and Ousten from 1941, where there was an agreement that there was going to be a hire purchase agreement between the parties, but there are lots of different types of hire purchase agreements, and so because that hadn't been completed, the courts were not going to infer that there was an actual contract between the two parties. Counteroffers also present an interesting example, and the idea is that an offeree, when they accept an offer, has to unreservedly assent to the terms of an offer. So if a new term is being introduced, then this acts as a sort of counteroffer and has the effect of destroying the original offer. Now that sounds a little bit complicated, but there's a good example in Hyde and Wrench where a piece of land was going to be sold for £1,000, and the other party came back and they said, I'm not quite keen on paying £1,000 for it, how about £950 instead? And that was rejected. And so that counteroffer then destroyed the original offer to sell the property for £1,000. So when the party then later came back and said, okay, I've had to think about it, and instead of £950, I will pay you the full £1,000. It was well within the rights of the parties to say that they rejected that agreement because the original offer had now by this point been destroyed. Now, distinguishing between a counter-offer and acceptance can actually sometimes be difficult, and it's important that we also say that a request for more information about a particular offer is not necessarily destroying the original offer as it stands, and the case with that is Stevenson and McLean. So if, for example, going back to the Hyde and Wrench example, they said, well, we will sell you this property for £1,000, and they came back and they said, okay, I'll think about it, but does that include the shed on the property as well? Then that's clearly not a counter-offer, that's just a request for more information. And so the original offer to sell the property for £1,000 would still stand. One of the interesting, more modern examples that comes up is when there is an agreement subject to contract. So there might be an agreement between two companies, but it has to be formalised by lawyers in a sort of official contract. And the idea here is that when there is that agreement between the parties and it is subject to contract, then it's not going to be binding until there is an actual contract between the parties. However, depending on the wording of the agreement, it might be that there is a temporary agreement in place. And so we saw the wordings provisional agreement used in Branca and Cabarro from 1947. Now, it is also perfectly possible for a contract to have retrospective effect and therefore to legitimate past conduct. And if we think back to that Brogden and Metropolitan Railway example where there was sort of an unspoken agreement between the parties that then later got formalised into a contract itself, we can think of that example and apply it here, because that later contract would also legitimate the past behaviour where the parties have actually been acting on the agreement itself. And so that's something that can actually be built into a contract, and that legitimisation of past behaviour is something that is also actionable within the courts. Now, it is important that there is at least a minimal degree of certainty within any sort of contract, and one of the ways that is potentially a way to get around this is the idea of letters of intent. And the best example here is where there is subcontracting. So say, for example, I have a building company and I put in a tender to do work on a block of flats. Now, my building company might be very good, but they might not be very good at the plumbing aspect of it. And so I might have to sort of engage with a subcontractor who is very good at plumbing. Now, the problem here is that I don't know if I'm actually going to get the tender to work on the building. So I need to sort of go to the plumber and say, look, I intend to work with you if I do get this tender, but can you sort of help out and maybe put some figures together? And the problem there is that it sort of puts the plumber in a very difficult position because they might have to actually go out and do some work, such as measuring the pipes and different things like that, before they can give me a solid estimate. Now, in that situation, it is possible that basically the plumber would be able to claim a certain amount of money on a quantum meruit basis. The idea here is that, say they do go out to the building and they go and measure up pipes and do some sort of initial estimates, then I would still have to pay them for that work, even if it doesn't mean that they go on and do the full amount of work in the end. And so these letters of intent in a contractual sense are quite sort of a nifty way for companies to avoid some of the full contractual obligations, but where there is at least a degree of certainty in any given contract, then that will give rise to liability. Now, whether there is actually a binding contract between the parties is often based on an objective stance towards that contract. And this tells us a lot about the way that courts will approach these particular cases. So they basically take a step back from the contract and they say, is there a binding contract between these two parties? Is there a clear meeting of the minds or a consensus between them about what is to happen in any given situation? So in some contracts we can have issues around certainty, and even something like the price might not actually be fixed at the time. And taking an approach where you sort of emphasize the importance of certainty,
You might be thinking at this stage, well, if you've not agreed the price, then that is going to be fatal for the contract and it won't be allowed to stand. But it is possible that the contract will stand as long as the thing like the price or the date of delivery is connected to something that is at least giving a degree of certainty. So for example, in the case that I put at the bottom of that slide there, which is Shell Limited and Lostock Garage from 1977, the price of petrol was fixed to whatever the price of petrol was on the day of delivery. And so because there is a sort of standardization there based on whatever the price of petrol is on that particular day, then there is enough certainty for that to get past the courts. And you can imagine a number of situations where that might come up, depending on, say, the sort of conversion rates between different currencies or something like that. In other words, there is some sort of connection to certainty, and it's not just left completely up in the air. Tenders are an interesting idea. The idea of a tender is that you would put in a bid to do certain work. So you can imagine, again, coming back to my building company who's going to do work on a block of flats. In a normal situation, we would put in a tender saying we can do the work and it will cost you £250,000 to do that work. And then the company would come back and say, yes, we accept. And then I would do that work for that amount of money. Or they would say, well, actually, someone has said that they can do it for £200,000, and so we're going to go with them instead. Now, that's a fairly straightforward example, but you can imagine a different situation where it would be a lot more difficult in a contractual sense to attract any degree of certainty, or to say that there has actually been a sort of full acceptance. So you can imagine if I was, say, for example, running a shop that sold phones, and I wanted to sell iPhones in my shop, but I wasn't quite sure how many I was going to sell. And so I might put a tender out to say, okay, who can supply me up to 100 iPhones over the course of this year? And someone might come back and say, yes, we can definitely do that. But the problem then is that I'm not going to then be bound if they sort of turn up with 100 iPhones. I could say, well, I'm not going to pay for that because I only said I needed up to 100 iPhones and I don't necessarily need all of these. So I can reject that particular aspect of the contract. And that's obviously a little bit difficult because we have a tender in place, but there is not really a true offer and acceptance. So how does that particular thing work? Well, say for example, we go back to my iPhones and I need 5 in January, 7 in February, only 2 in March. And we eventually build up over the year to up to 100 iPhones. Well, each of those individual deliveries in a particular month is going to be recognised as a separate contract, and that's come from the Great Northern Railway Company and Witham from 1873. So that first contract in January is a particular offer and acceptance, and that's how we create the certainty that's needed in that given contract. Now the second part of this lecture is the communication of the acceptance itself. Has it actually been communicated to the offeree? And this requires normally some form of words or actions from the offeree to the offeror, to the person who is making the offer. And the idea that you need only sort of words or actions means that silence is generally not going to constitute acceptance. The classic case for this is Feldhaus and Bindley to do with the selling of a horse from a nephew to an uncle. And the uncle wrote to the nephew and said, if I do not hear any more about him, I consider the horse mine at that particular price. And this puts the nephew in a particularly unfortunate situation, really, because then if they say forget about the letter or they don't manage to respond, then the idea would be that they would have sold the horse. But that's not really very fair, because they might not actually want to do that. So what happens in that situation is that silence is not going to constitute acceptance, and the uncle can't simply demand that he has the horse just because his nephew hasn't actually responded to a particular letter. On the other hand, there are some situations in which the need for communication can be waived. So in Carlisle and Carbolic Smokeball Company, which is the famous case that we mentioned last time in the lecture on offers, in that situation, Mrs. Carlisle, who was bought the smoke ball after seeing the advertisement in the newspaper, doesn't need to write to the company and say, I accept your offer and I am going to use this smoke ball. Instead, she accepts the offer by simply performing the action, and so there isn't really a communication of acceptance, but there is an implied waiver of communication because the company knows that people aren't going to directly respond and accept their offer. In some situations, there may also be a prescribed mode of communication, and the offeror can demand that communication takes place in a certain way. But generally speaking, if the person who accepts the offer does so in a way that is equally or more efficient, then that will constitute valid acceptance. So if they say that you can respond to an offer by post, but instead you call them up and accept, because calling them up is actually more efficient, that will constitute valid acceptance. On the other hand, if they said you can only respond by post and by post only, then you would have to respond to the offer and accept it by post, and that would be a clear indication, although it would probably be a little bit harsh. And the case for that is Tin and Hoffman from 1873. What if a mode of communication isn't prescribed? Well, that can then depend on the offer itself and also the surrounding circumstances of the case. If the two people are stood next to each other in person, then it might be expected that the communication of acceptance would also be in person. Similarly, if there is sort of negotiations that have been taking place over email, then if the final offer comes over email, it might be expected that the acceptance also goes via email. Now, generally speaking, acceptance when the parties are in the presence of each other is not complete until it is actually received by the offeror. So although it's an old case, Torres Limited and Miles Far East Corporation from 1955 was based on a system called Telex, which kind of operated as a sort of early version of text messaging. And the question in the case was where the acceptance actually took place. The text message was sent from Holland and it was received in London. And because acceptance is not complete until it is actually received, because that telex message was received in London, that is where acceptance took place, and that was the legitimate jurisdiction. Now, when the parties are not in the same place or in each other's presence, whether that is literally because they're in the same room or virtually because there's some sort of instant messaging system such as Torres, then the problem is that the rule that acceptance has to be communicated to the person who is making the offer is not exactly very practical. And so the response to this of the legal system was to establish something called the Postal Rule, which comes from an 1818 case called Adams and Linsell. And the premise here is that acceptance actually takes place when the letter of acceptance is put into the post, not when that letter is actually received by the person making the offer. And so we have an exception to that normal rule that the offeror has to have actually received the acceptance. This postal rule can actually create a potentially unfair situation because, say for example, I am accepting an offer and doing so by post. As soon as I put my letter of acceptance into the post, I have accepted that offer. But say 30 minutes later, I decide actually I don't really want to accept that offer at all. And so I call the person up and say, look, in a couple of days, you're about to receive a letter saying I accept your offer. I actually don't mean that, and so I would appreciate it if you just ignore that letter completely. The problem is that this basically allows me to have my cake and eat it, because I can accept the offer and also revoke my acceptance after the fact. And so a lot of Commonwealth authorities have basically suggested that I can't do this. And so the postal rule applies strictly. And so as soon as I have posted that letter is an acceptance and there is a contract formed between the two parties. Now, speaking of Commonwealth cases, the Crown against Clark from 1927 is a Commonwealth case from Western Australia. And the idea here is between knowledge of the contract itself. Now, remember we said at the start that the courts are looking for an agreement between the two parties. Now, if one of the parties doesn't actually have a sense of agreement because they weren't aware that there was an offer to be accepted, then the contract will not actually stand. So the Crown against Clark is a really interesting case because it was to do with an offer for a reward about information that would lead to the capture of a criminal. And Clark gave up this information, but it later transpired that they weren't actually aware of the offer of a reward for that information. And so because Clark didn't have that particular knowledge, he was not able to claim the reward, and so he lost out in that particular situation. However, in a similar situation in Williams and Cowardine from 1833, the person was aware that there was a reward for information, and so they were able to claim it. Now, that wasn't their main motive for giving up the information. They actually wanted to help clear their own name, and so it wasn't even a primary factor of motivation, but the fact that they knew about the reward was enough for them to be able to claim it in the end. The final point that we can make on this subject is to do with the idea of cross offers, and this is probably more of an academic point more than anything else, because it's not something that is really likely to come up in a real life situation. But say, for example, I had a friend who was going to be selling their car for £5,000 or something like that. Now, at the same time that I sort of think I will put in an offer to buy that car for £5,000, at the same time, my friend might know that I'm looking for a car, and they might send me a letter that say offering to sell me the car for £5,000. Now, at that point in time, we have me offering to buy the car and them offering to sell the car at the same amount for the same sort of consideration. It's the car for £5,000. But the problem that the law would have in that situation is that there hasn't actually really been an acceptance. It's just two parties making sort of identical offers to each other. And so one of us would have to actually accept it in order for that to go ahead. So even though there is a clear agreement between the parties, the law is still looking for acceptance. And so this really final point is just to emphasize the importance of acceptance within contract law and those four elements of the contract: offer, acceptance, consideration, and the intention to create legal relations.
So whenever a contract comes up as part of a problem question, you not only need to look at the offer but also the acceptance as well, and try and come to a conclusion that there is or is not an agreement between the two parties. Now, when we're considering acceptance in particular, we've seen that you have to be thinking about two different aspects of acceptance. First of all, is there the fact of acceptance? In other words, has the offeree actually accepted the offer? And then there's also the communication of that acceptance as well. And we saw how there are lots of different rules, such as the Postal Rule from Adams and Linsell, that need to be at the back of your mind whenever you're considering these types of questions. And that's the way you're going to be picking up the big marks, when you can cite case law and talk about the different rules that apply in different circumstances. Well, that's all from me on acceptance. Hope you enjoyed this lecture. If you did, make sure to give it a like and subscribe to the channel. If you've got any questions or any comments, then leave those below and I'll do my best to try and get back to you. Thanks very much for watching. Bye!